Imagine you have a rule book. But no one can punish you if you break it. Sounds useless, right? Wrong. That rule book is the reason India has Magnrega. That rule book is the reason you have free legal aid. That rule book is the reason India calls itself a welfare state. Welcome to Chapter 8 of Indian Polity, Directive Principles of State Policy. Or as we call them, DPSPs. I'm going to tell you something right now. In the UPSC Prelims, this chapter has given questions in almost every single year. 2013, 2015, multiple times. And in mains, especially GS2, this chapter is gold. So buckle up. By the end of this lecture, you will not just know DPSPs, you will understand them. And in UPSC, that difference is everything. What is DPSP? Origin and meaning. So where did this concept come from? DPSPs are enshrined in Part 4 of the Constitution, covering Articles 36 to 51. The framers of our Constitution borrowed this brilliant idea from the Irish Constitution of 1937, and Ireland itself had copied it from the Spanish Constitution. So it's like a constitutional relay race, Spain to Ireland to India. Now, Dr. B.R. Ambedkar, the chief architect of our Constitution, called DPSPs a novel feature of the Indian Constitution. That's a quote you must remember for mains. And the legendary constitutional scholar Granville Austin described both directive principles and fundamental rights together as the conscience of the Constitution. Now my handwritten notes add something crucial here. B.N. Rao, who was the constitutional advisor to the Constituent Assembly, he proposed dividing rights into two categories, justiciable and non-justiciable. The drafting committee accepted this. That's how DPSPs became non-justiciable while fundamental rights became justiciable. So the very structure of Part 3 versus Part 4, it was B.N. Rao's idea. Remember that name. Purpose of DPSP. Now, here's the most important question, why do DPSPs exist? The purpose of DPSP is to establish social and economic democracy. This will help India grow as a welfare state. Notice what it says, social and economic democracy. We already had political democracy through voting. But was that enough? Could a hungry person truly enjoy democracy? No. That's why DPSPs were added to complete the picture. But here's a critical point from the notes, the aim of DPSP is not to establish a religious state. This is important. India is secular, and DPSPs reinforce that. Now, another crucial note, DPSPs do not constitute limitations upon executive or legislative functions. Don't confuse them with restrictions. They are positive obligations. They direct the state to do something good, not stop them from doing something bad. That's the job of fundamental rights. Think of it this way. Fundamental rights is equal to negative obligations, state should not do this. DPSPs is equal to positive obligations, state should do this. Beautiful contrast. Remember it. Key features of DPSP. Let's now lock down the features of DPSPs. These are directly asked in prelims. Feature 1, DPSPs are constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. They tell the government what to aim for. Feature 2, this is the big one. DPSPs are non-justiciable. That means no court can force the government to implement them. If the government ignores a DPSP, you cannot go to the Supreme Court and say enforce this. However, and this is critical, Article 37 says they are fundamental in governance. The state has a duty to apply them while making laws. So they are non-enforceable but not unimportant. They are not enforceable by any court. But these are fundamental in the governance of the country, Article 37. Feature 3, even though courts can't enforce DPSPs, they use DPSPs. When a court tests whether a law is reasonable and constitutionally valid, it harmonizes the law with DPSPs. So DPSPs help the judiciary indirectly. Feature 4, they are harmonized with fundamental rights. We'll see the entire evolution of this relationship later with landmark cases. Feature 5, their scope is massive economic, social, political, environmental and international principles. Full 360-degree coverage of what a modern welfare state should do. DPSP and the instrument of instructions concept. Here's something many students skip, but UPSC loves it. Ambedkar himself said that DPSPs resemble the instrument of instructions enumerated in the Government of India Act, 1935. Those were instructions issued by the British government to the Governor-General and Governors of Indian colonies. But the difference is crucial, the colonial instrument of instructions were orders from a foreign power to subordinate officials. DPSPs are constitutional directions from the sovereign people of India to their own elected government. That's a massive difference in dignity and intent. Now, one thing the Laxmikanth textbook makes clear, DPSPs are instructions to both the legislature and the executive. So it's not just Parliament, even the executive branch must keep these in mind. Classification of DPSPs. Now comes the most important section for prelims, the classification of DPSPs. DPSP may be classified into Socialist, Liberal Intellectualistic, Gandhian. UPSC alert, the Constitution does not officially classify DPSPs into these categories. This classification is done by scholars and academics, including Laxmikanth, based on the content and direction of these principles. Don't get confused if a question says the Constitution classifies DPSPs into, that would be wrong. Now let's go through each category in detail. Get ready, this is going to be a deep dive. Socialist Principles, Articles. Let's start with the Socialist Principles. These are about economic justice, making sure wealth doesn't stay in the hands of a few, and that every citizen gets a fair shot at life. Article 38, the state must work to establish a social order that promotes justice, social, economic, and political. And it must minimize inequalities in income, status, facilities, and opportunities. Article 39, this is a packed article. Read carefully. A. Equal right to livelihood for men and women. B. Distribution of resources for common good. C. Prevention of wealth concentration. D. Equal pay for equal work. Here, Parliament passed the Equal Remuneration Act, 1976. My handwritten notes specifically highlight this connection. E. Health and safety of workers and children. F. Healthy development of children, added by 42nd Amendment, 1976. Article 39A, free legal aid. This was inserted by the 42nd Amendment Act, 1976 to provide free legal aid to the poor and weaker sections of society. My notes say this is a key exam point. Article 41, right to work, right to education, and public assistance in cases of unemployment, old age, sickness, and disablement. Article 42, just and humane conditions of work and maternity relief. Article 43, living wages and decent living standards for workers. Article 43A, participation of workers in the management of industries. Also added by the 42nd Amendment Act, 1976. My notes specifically mention this, the participation of workers in the management of industries was added by 42nd Amendment Act, 1976. Article 47, raise the level of nutrition and standard of living and improve public health. It also talks about prohibition of intoxicating drinks and drugs, which is why states can impose liquor bans under this article. Now here's a beautiful UPSC connection from my handwritten notes. MGNREGA, Mahatma Gandhi National Rural Employment Guarantee Act, aims to guarantee the right to work. It ensures livelihood in rural areas by providing at least 100 days of employment in a financial year to every household for unskilled manual work. This directly fulfills Article 41 of the Constitution. Gandhian Principles, Articles. Now let's talk about Gandhian Principles. These are based on Gandhi's vision for India, village republics, cottage industries, prohibition, and upliftment of the weakest sections of society. Article 40, my handwritten notes highlight this specially. Panchayati Raj system is under DPSP, Art 40. Art 40 says state shall take steps to organize village panchayats and endow them with such powers and authority to enable them as units of self-government. Beautiful. The entire concept of village self-governance, that's Gandhi's dream encoded in the Constitution. Article 43, promote cottage industries in rural areas. Gandhi famously championed the charkha and village industries. This article keeps that spirit alive. Article 43b, this is new. Added by the 97th Constitutional Amendment Act of 2011, it directs the state to promote voluntary, autonomous, democratically controlled, and professionally managed cooperative societies. Remember the year 2011, 97th Amendment. Article 46, promote educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. Also protect them from social injustice and exploitation. Article 47, we already covered this in Socialist Principles, it's both. Prohibition of intoxicating drinks fits Gandhi's vision. Nutrition and public health fit socialist welfare goals. So Art 47 appears in both categories. Article 48, this is very important for prelims. It speaks of prohibiting the slaughter of cows and other milch and draught cattle and improving their breeds. Also covers organization of agriculture and animal husbandry on modern scientific lines. Article 48 directly, prevention of cow slaughter, organization of agriculture and animal husbandry. Clear and direct. Liberal intellectual principles, articles. The third category, liberal intellectual principles. These represent the more progressive, modern, and rational vision for India, one that goes beyond economics and villages to talk about law, environment, and even international peace. Article 44, Uniform Civil Code. This is perhaps the most debated DPSP today. It directs the state to secure a uniform civil code throughout the country. A common set of laws for all citizens regardless of religion, in matters like marriage, divorce, inheritance. Currently, we have personal laws based on religion. This article remains unimplemented, but the debate around it is very much alive. UCC, Uniform Civil Code, was not added by 42nd Amendment Act 1976. It was inherent in the Constitution. This is a crucial exam trap. Don't confuse UCC addition with 42nd Amendment additions. Article 45 originally about free and compulsory education for children up to age 14. But this was changed by the 86th Amendment Act of 2002. Now Article 45 provides for early childhood care and education for all children until they attain the age of 6 years. After 6 years, education becomes a fundamental right under Article 21A, Right to Education. My handwritten notes capture this perfectly. Article 48 Modern Agriculture and Animal Husbandry. This overlaps with Gandhian too, it's about scientific modern farming. Article 48A Protect and improve the environment and safeguard forests and wildlife. This was added by the 44th Amendment Act of 1978. This is the constitutional basis for all our environmental protection laws. Article 49 Protect monuments, places, and objects of artistic or historic interest that are declared of national importance. Think ASI, Archaeological Survey of India, and the Heritage Scheme. Article 50 Separation of Judiciary from the Executive. The state shall take steps to separate the judiciary from the executive in the public services of the state. This is about judicial independence. Article 51 Foster international peace and security, maintain just and honorable relations between nations, respect international law and treaty obligations. India's foreign policy philosophy, Panchsheel, draws its inspiration from this article. Amendment to DPSPs. DPSPs are not frozen in time. Parliament has added new directives through constitutional amendments. Let me walk you through each one. These are direct prelims questions. 42nd Amendment Act, 1976. This is the most important amendment for DPSPs. It added 4 new directive principles. Article 39A, Equal Justice and Free Legal Aid. Article 43A, Participation of Workers in Management of Industries. Article 48A, Protect and Improve the Environment, Forests and Wildlife. Article 39F, Opportunity for Healthy Development of Children. Article 39A, Free Legal Aid, was inserted by 42nd Amendment Act 1976 to provide free legal aid to the poor and weaker sections of society. And critically from the notes, UCC, Uniform Civil Code, was not added by 42nd Amendment Act 1976. It was inherent in the Constitution. This is a classic prelims trap. 44th Amendment Act, 1978 added Article 38 to state to minimize inequalities in income, status, facilities, and opportunities. 86th Amendment Act, 2002 modified Article 45. Earlier it was about free education up to age 14. Now it's about early childhood care and education for children up to 6 years. Education after 6 became Art 21A. 97th Amendment Act, 2011 added Article 43B about promoting voluntary, autonomous, democratically controlled, and professionally managed cooperative societies. DPSPs outside Part 4. Here's something most students don't know, and UPSC tests exactly this. There are directives in the Constitution that are not in Part 4, they are not between Articles 36 to 51, but they still function like DPSPs. These are directive-type provisions spread across other parts of the Constitution. Article 335. It directs that the claims of members of scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the Union or a state. This is in Part 16. Article 350A, this is in Part 17, Languages. It directs every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 351, also in Part 17. It directs the Union to promote the spread of the Hindi language, develop it so that it may serve as a medium of expression for all the composite elements of Indian culture. Notes have highlighted all 3, and added, all are non-justiciable. Same nature as DPSPs, non-enforceable, but important. This is a beautiful trap question. Which of the following are directive principles of state policy, and they put Article 335 or 350A? The correct answer, they are directive-type provisions, but not technically DPSPs, which are only Art 36 to 51 in Part 4. FRs versus DPSPs, the difference. This is the table that has been asked in UPSC Prelims multiple times, directly and indirectly. Let me make it crystal clear. Fundamental rights are justiciable, meaning they are legally enforceable. If your FR is violated, you can directly go to the Supreme Court under Article 32 or the High Court under Article 226. The courts must protect them. Directive principles are non-justiciable, no court can force the government to implement them. They are not legally enforceable. FRs are negative obligations, they prohibit the state from doing certain things. State shall not discriminate on grounds of religion. State shall not deny freedom of speech. DPSPs are positive obligations, they direct the state to do something. State shall promote equal pay. State shall provide free legal aid. FRs promote political democracy, your right to vote, speak, practice religion. DPSPs promote social and economic democracy, your right to food, work, fair wages. FRs are automatically enforced, the moment they are violated, courts step in. DPSPs require legislation, Parliament needs to make laws to implement them. Now here's a beautiful quote from my handwritten notes. FRs are negative limitations, DPSPs are positive obligations. Perfect for mains answers. And remember what Granville Austin said, they are like two wheels of a chariot. One without the other is incomplete. The Constitution calls this the doctrine of harmonious construction. FRs versus DPSPs, landmark cases. The constitutional battle between fundamental rights and directive principles. This is a timeline of landmark Supreme Court cases that shaped Indian democracy. 1951 Champakam Rajan case. This was the first major clash. The Supreme Court ruled that FRs prevail over DPSPs, Parliament cannot take away any FR even for implementing a DPSP. FRs are supreme. FRs could be amended by Parliament through constitutional amendment. 1967 Golaknath case. The Supreme Court went even further, Parliament cannot remove any fundamental right. FRs became sacrosanct. The court said FRs cannot be amended even for implementing DPSPs. This shocked Parliament. 1971 24th Amendment. Parliament reacted. It inserted Article 31C which said laws giving effect to Article 39B and C, the socialistic DPSPs, shall not be void even if they violate Articles 14 and 19. Also inserted that Parliament can amend FRs via constitutional amendment. This was Parliament's strike back. 1973 Kesavananda Bharati case. This is the most important case in Indian constitutional history. The Supreme Court upheld 24th Amendment but established judicial review as a basic structure of the Constitution. The second provision of Article 31C, which made DPSP laws immune from any court challenge, was struck down. The basic structure doctrine was born. Parliament can amend FRs for DPSP implementation, but cannot damage the basic structure. 1976 42nd Amendment. Parliament, led by Indira Gandhi's government, tried to extend Article 31C to all DPSPs, not just 39B and C. It said laws giving effect to any DPSP shall be immune from challenge under Articles 14 and 19. 1980 Minerva Mills case. The Supreme Court struck down this extension of Article 31C. It ruled that giving absolute primacy to DPSPs over FRs would destroy the balance that is an essential feature of the Constitution, i.e., the basic structure. It emphasized harmony between FRs and DPSPs. Present position. FRs hold supremacy over DPSPs. However, Parliament can amend FRs for DPSP implementation so long as it does not damage the basic structure. It's a balance, not a domination. Criticism of DPSPs. Even great ideas face criticism. Let's look at what critics have said about DPSPs, because UPSC mains sometimes asks, critically analyze DPSPs. Criticism 1. No legal force. K.T. Shah, a member of the Constituent Assembly, famously said, DPSP is a check which is paid on bank's convenience. My handwritten notes highlight this quote specifically. What he meant was, the government can implement DPSPs whenever it wants to, not when it has to. Just like a post-dated check, the bank, government, pays when convenient. Nasiruddin called them pious superfluities. K.T. Shah called them a check on bank's convenience. Sir Ivor Jennings called them pious aspirations. Krishnamachari called them veritable dustbin of sentiments. But remember, these were criticisms at the time of framing. History has proven them wrong. Criticism 2. Illogically arranged. Critics like N. Srinivasan said DPSPs are neither properly classified nor logically arranged. The provisions mix old and new ideas, economic and social questions without a consistent philosophy. Criticism 3. Conservative. Sir Ivor Jennings said DPSPs are based on 19th century political philosophy and may not be suitable for 20th century India. The Constitution expresses Fabian socialism, which is outdated. Criticism 4. Constitutional conflict. K. Santhanam pointed out that DPSPs can lead to constitutional conflicts between center state, parliament executive, president PM, governor CM. When DPSPs give directions to the state but the state government is of a different political ideology, conflict happens. Utility and importance of DPSPs. Now let's flip the coin. Why are DPSPs actually brilliant? Point 1. DPSPs are like an instrument of instructions to all state authorities, legislative and executive. They remind the government of the new social and economic order that the Constitution aims to build. Point 2. Courts use DPSPs to determine constitutional validity. When testing the reasonableness of any law, courts look at DPSPs. Laxmikanth says they have served as useful beacon lights for the courts. Point 3. Though they are non-justiciable, they impose a moral obligation on the government. Any government that ignores DPSPs will have to answer to the electorate at the next election. My handwritten notes say, if any government ignores them, it will certainly have to answer for that before the electorate at the election time. So DPSPs have political force even if not legal force. Point 4. DPSPs aim to foster social revolution, to establish a welfare state. They lay down the goals of the social revolution, and laws like Minerva, Right to Education, Legal Services Authorities Act are all inspired by DPSPs. Point 5. They supplement fundamental rights. FRs protect the individual from state tyranny. DPSPs direct the state to actively serve the individual. Together complete protection. Point 6. They are an excellent test for political parties. A ruling party that doesn't work towards DPSPs can be judged and defeated. They serve as a kind of political manifesto of the Constitution. Implementation of DPSPs in modern India. Now let's see how DPSPs have actually shaped India. This is the answer to all the critics. Planning and Economic Management. The Planning Commission was established in 1950 to implement DPSPs in a planned manner, securing socio-economic justice and reducing inequalities. In 2015, it was replaced by Niti Aayog. Land reforms. Almost all states passed land reform laws, abolition of zamindari, ceilings on land holdings, distribution of surplus land among landless laborers, security of tenure, all to fulfill DPSPs about equitable distribution of resources. Labor laws. Minimum Wages Act, 1948, Payment of Bonus Act, 1965, Contract Labor Act, 1970, Equal Remuneration Act, 1976, Maternity Benefit Act, 1961, all inspired by Articles 42, 43, 39d. Magnrega. The Mahatma Gandhi National Rural Employment Guarantee Act ensures 100 days of employment to rural households, directly fulfilling Art 41. National Social Assistance Program launched by Government of India on 15 August 1995 fulfills the provisions of DPSP regarding right to work. Article 36 and 37. Before we close, let's understand the two foundation articles of Part 4. Article 36 simply defines what state means in Part 4. And it says, same meaning as in Article 12 in Part 3. So state in DPSP context includes Parliament, all state legislatures, central and state governments, all local authorities, the entire government machinery. Article 37 is the heart of DPSPs. It says two things. 1. DPSPs are fundamental in the governance of the country. Not enforceable but fundamental. The state has a duty to apply them in making laws. 2. They are non-justiciable. Not enforceable by courts. So Article 37 simultaneously makes DPSPs important, fundamental in governance, and non-enforceable, not justiciable. This beautiful paradox is what makes DPSPs unique in the world of constitutional law. The Laxmikanth textbook says it clearly, though the directive principles are non-justiciable, the Constitution, Article 37, makes it clear that these principles are fundamental in the governance of the country and it shall be the duty of the state to apply these principles in making laws. Let's do a rapid recap everything we covered today. You've now mastered Chapter 8. Don't just revise, apply this knowledge. In the next video, we'll tackle fundamental duties. Until then, keep studying, keep believing.